Court sitting on air cases in air this legal vacation as per air controversies in air recent days. Now, is there anything an answer does air attaching and then a client know something we do not know? I think so. No. What is the fear of lawyer attaching and then a client on air court sitting on air case in air this legal holidays? Dr. Justice Srimsai Akasa na ɔde expose bi atodwa atachia ne secret plans enti a ɔmpɛ sɛ ɛyɛ court no ɛbɛtena ase on air this legal vacation on Radio Gold atodwa. Now, some of the informations no are very shocking. Me pesa obeka me ho na yakoti the details from Dr. Justice Srimsai ne expose a ode atodwa on attaching secret plans intia on pesa court ebetena se on this legal vacation.
My never I say ma PENDREAM TV. PENDREAM TV there o see them yopo.
I've wondered, do attorney generals go on vacation?
Our individual lawyers, just like any other worker in Ghana, are entitled to annual leave. So what we do is to schedule each lawyer and their leave periods across the year. So there is no point in time where the Office of Attorney General would shut down or even say that a significant majority of our staff, our members of staff are on leave so that there will not be full work. So we don't have anything like vacation or legal vacation at the Attorney General's department. So we are working fully.
I see. So you wouldn't be taking a 2-month vacation?
No. We don't have anything like that.
So you are entitled to leave.
I can tell you on authority that even law firms don't run that. Private law firms don't take that vacation. Let me explain what this vacation thing is about.
Okay.
The legal vacation is not lawyer's vacation. That's the first thing. It is also not that courts are on vacation. It is only the judges of the superior courts who go on vacation between the month of August and September. Even lower court judges, that is those who sit in district courts and circuit courts, family tribunals, and all the other lower courts, they don't go on this legal vacation. So as we speak, if you have a case in the district magistrate court or in the circuit court, the cases would be going on and the judges are coming, and those judges go on annual leave just like any other worker in the country. So this legal vacation is actually being stretched for the first time in our history out of its scope. And this is happening because I believe some individual lawyers have a different or have developed a sudden different understanding of what the vacation is. When it is legal vacation, that is in the month of August and September, because the Superior Court judges go on this vacation, and because common sense as well as law knows that you cannot shut down a justice system, even with the Superior Court, the Chief Justice is given the power by law to appoint what we call vacation judges to hold the fort while a majority of the Superior Court judges go on this vacation. These judges who hold the fort are often called vacation judges. And because they are vacation judges, cases in other courts. So, for example, let's say I am a vacating judge and I'm in the Human Rights Court 1. The Chief Justice will assign cases from, let's say, Human Rights Court 2, General Jurisdiction 3, General Jurisdiction 5, all the cases in other courts, they will assign those courts to me to manage over the vacation. So if you are in those other courts and you have any cases that are urgent, motions, applications, and summons, it is the judge sitting in the Human Rights Court 2 who would, be the one who conduct those cases, in addition to the cases in his own court. So if you look at a typical permission by the Chief Justice to a judge to sit as a vacation judge, we call it a warrant. If you read the warrant, you would see that the Chief Justice will tell the court, the justice who is the vacation judge, that you will continue to sit in your court, and in addition to that, cases coming from other courts will be coming to your court for adjudication. Now, this is the difference. For cases that are coming from other courts, the principle is that it is only the judges in those courts, the original judges in those courts, who have the power to conduct the case, to end the case. So the vacation judge cannot end the case in another court. So any motion or any court process which is capable of ending the case, the vacation judge will not hear them. However, in his own court, once he's sitting in his own court, he has the power to conduct his cases the way he wants. In other words, all the cases in his own court, he can hear them fully and end them. He can do motions, he can do sermons. If a new case comes, he will do the case as if, he has the power to conduct the case once he has the warrant, and he will conduct the case as if his court is not on vacation. So this is where the question comes in. Now, during the vacation, the truth of the matter is that because a majority of the courts are on vacation, private practitioners also plan their life in a way that they do not have to do so much court trials over the vacation. So private lawyers also take advantage of that vacation to relax and to lower the level of work they do. So that is the practice. Now, this relaxation of a private lawyer and his private firm affairs has nothing to do with the power of the judge, who is a vacation judge, to conduct his cases and to run his court. So what happens is that during this period, when I was a private lawyer, when we come to court, we tell the judge that, my lord, we have planned this and this and this. So if it is possible, this case, can you adjourn it for a very long time or for some couple of weeks for us to do those things so that we do not come to court? Whether it is a motion or whether it is whatever, the point is that you always have to come to the judge, the vacation judge, to plead, and then the lawyer on the other side, just like any normal hearing, we will judge or argue and then we will agree on a compromise. Sometimes we agree that we agree and the judge will also accept that we wouldn't come until maybe October. Sometimes the agreement doesn't work, and then the judge will impose his own wishes on the lawyers as to when he wants them to come. But the fundamental principle is that it is the judge who has the final say, like in any other case, to adjourn cases. Now, what these lawyers, I'm talking of Kwabena Dubuahin's lawyer, Hanan's lawyer, Solomon Samuel's lawyer, what they are saying is that this privilege that judges give us every time during vacation to adjourn cases and manage cases so that we can also have time, they are saying that it is a right in them, that is the private lawyer, to determine whether the case will come on, and that if any of the two lawyers said that he is not available to attend court, then the judge has no power but to accept it and take the case to the term time. Now, Ghana Bar Association also threw its weight behind its new understanding of what legal vacation is. In other words, Ghana Bar Association is also saying that when it comes to legal vacation, it is lawyers who determine what the court should do, not the judge. And our position is that there is no basis for any person to say that a lawyer is the one who determines what should happen in court. It is always, whether in term time or in vacation, the judge's discretion and power to determine when to adjourn cases, how to handle cases. And the lawyers don't have any, the lawyers can only, as in all cases, lawyers can only suggest that the judge will have the final say. Now, what is even bizarre about what they are doing is that they are not even coming to the court to plead with the judge to give them time. They are saying that they will not even come to the court for the judge to even have a say as to whether to adjourn the case or not. They won't come because it's their right to decide whether to come or not. And this is what the Ghana Bar Association is throwing its weight behind. Now, let's look at this thing. Is it truly the case that it is lawyers who determine what should happen in court during the legal vacation? You and I have been in this country for some time, and we have followed law cases, and I'm sure many of our listeners have followed law cases. There have been many, many, many times where vacation courts have heard and tried cases even when lawyers have protested. And the names are many. In fact, Justice Georgina Wood declared that the whole of commercial courts in Kumasi and Accra were going to work normally throughout the legal vacation in 2011. We have witnessed Justice Afre, who has tried quality grain cases during the vacation. Recently, my own very good friend, Samseladi, there's a record where he has, I think last year or so, or 2020, he has conducted a full trial during the legal vacation, even amid the protest from the other council. So, not only is it the case that no law supports what the GBA and the lawyers are saying, even practice doesn't support what they are saying. But we are insisting on doing that. Now, there's even a more serious thing on this issue. You see, when the vacation judges, as they are sitting now, when the courts resume, they are also entitled to take their vacation. So, from October, November, these judges who are sitting as vacation judges will also rise and go for their vacation while the other judges can. And their cases will be sent to other courts. And when their cases are sent to those other courts, those judges cannot do substantive matters. They cannot try the case. So they would have to wait. Now, what the GBA proposal is, that the implication of the GBA proposal is that these courts cannot conduct any case until next year, January. You know why? Because if they are not allowed to conduct their cases now, from November, December, they will also go on their legal vacation. So no one can conduct their cases either. And then in December, there's another legal vacation, and the year will start in January. The legal year will start in January 15th or so. So basically, what they are doing is that none of these cases will be heard now, and they will also not be heard when the court resumes until next year. Now, I'll take you through the cases individually, and you will see that this whole thing is just planned to delay these cases. Now let's take Kwabena Dubois. In Kwabena Dubois' case, our last witness, that prosecution's last witness, has been in the witness box for at least 3 months.
3 months?
Just before 3 months. Just
one witness?
Yes.
Is it
the legal vacation. Pardon?
So I wanted to just clarify before you continue. Is it your examination that has dragged for so long, or is cross-examination?
No. It is, in fact, he has been cross-examined. He has been the witness for cross-examination for 3 months. So, in other words, Kwabena Dubois' lawyer has been cross-examining this witness for 3 months.
Hey.
Getting to the end of the legal year, the judge had the cause to declare that the witness has stayed in the box for too long and that counsel should ask relevant questions, and has given the lawyer one more sitting for him to finish the cross-examination. Now, this one more sitting was what was supposed to happen on Tuesday. So on Tuesday, if Lawyer Atta had come to court and done the cross-examination, that would have ended our case, and this is what will follow. The judge would give him at least 2 weeks to file a submission of no case. We will be given another 2 weeks or so to also file our opposition to the submission of no case, after which the judge himself will take maybe 2 or 3 weeks to write his ruling. That already takes us into what? September. And in this September, there will not be any work. We will not have to come to court during all this period. Then, after the judge gives his ruling, if the ruling goes in favor of the accused person, then the case ends. If the ruling doesn't go in favor of the accused person, then the judge will give the accused person another 3 weeks to file his witness statement. Then we will now do CMC, which will take us out of the legal vacation into 10 times. So you see, even the whole noise that is being made on this vacation, it's only 1 day of work that will happen during the vacation, 1 day of proper trial.
Okay.
So you see the point. Now, if you look at it this way, it will be clear to you that the whole noise, this sudden deliberate misunderstanding of legal vacation that is become an issue, is only directed to prevent that one single hearing to come on. And you know why? Because let me put it this way. If you're a lawyer, okay, and you know that you have a good case and that your submission of no case will succeed, would you not be in a hurry to do this 1 day, and then when they give you time to do your submission of no case, you file it, and then at the end of the day, your submission of no case ruling will be given during the vacation. So by the beginning of next term, you don't even have to come to court because you would have won the case. Would you not prefer that to what is happening? But I leave the judgment to you to see. Let me go to another case. The Solomon Asamoah SkyTrain, where the lawyers have also filed. In that case, we ended our case, I think, somewhere in April. Then the judge was time for the accused person to file submission of no case. They filed the submission of no case. We filed our opposition to it. The submission of no case was dismissed. And the judge gave them 21 days to file their defense. What the law says is that if a judge gives an order, you're supposed to comply with the order. If you have not complied with the order, you cannot be coming with other applications asking for the court's, further orders. 21 days passed. These accused persons refused to file their defenses, which took us to the beginning of the legal vacation. And the judge gave them another 21 days from the 30th of July to file these defenses. Now, they have written a letter to the Chief Justice complaining that they are not supposed to work during the legal vacation. But filing your witness statement is not trial. This is something that even if you were not even if it was a legal vacation or not, you would have still filed it and it would not amount to what? The hearing of the case. So you see, they have in their case, there will not even be any hearing during the vacation, because when they file their witness statement, we will take a date and we will come and do CMC. CMC is not trial. And then it is after the CMC that the judge will actually set a date for the trial to continue, which will definitely take us out of the legal vacation. So again, in this particular case, there's actually no real work to be done during the vacation. So clearly you see that the whole idea is not about legal vacation. It is simply to just make sure that the case doesn't go on, and then when the term resumes, the judges who are now on legal vacation are conducting these cases would also go on vacation, which means nothing will go on again, and the case will now continue next year. That is a bigger picture I see here. So this propaganda that is being made, for example, if you listen carefully to the narrative, especially from Atta, he keeps repeating the fact that the Chief Justice has selected his clients and some two MPP cases and have asked judges to try them in the vacation. This is absolute falsehood. And sometimes I feel embarrassed when these falsehoods are being peddled. If you the Chief Justice's warrant to these judges is not that does not even mention any case. There are 11 judges in the Greater Accra region alone who are sitting during this legal vacation.
Okay, 11.
11. In the whole of Ghana, there are about 30 judges sitting as legal vacation judges. So why would a lawyer say that a warrant being given is only for his cases and it's for only NPP cases? Now, we have a couple of oral cases. Some of our oral cases are not before any vacation judge. They are before other judges who have gone on vacation. So the Wuntumi cases, for instance, the remaining Wuntumi cases, the one on Samra Boy and the Exim Bank, for instance, the judges in those courts are on vacation. So we will not be able to do anything because they are not there, and we can't go and do it in another court. So, and Lawyer Atta is the lawyer for Wuntumi on these two cases. So he knows very well that it is not all oral cases that are being conducted during the vacation. Yet he is creating the impression deliberately to mislead the public that a Chief Justice is being partial and is persecuting his clients. And the vacation judges are not hearing only oral cases. Any cases, all the cases in their court are being heard. You will remember that even OSP people went to court earlier this week. OSP cases are not oral cases, but their cases are being heard. Private persons and their cases are also being heard during the vacation, so long as it's before the vacation court. So the falsehood that only his client cases have been selected and are being heard is so unfortunate. And a lot of people are believing these falsehoods.
I see. So you are saying that this matter could have been, even if they wanted a long adjournment, it could have been resolved in the courtroom.
Oh yes, that is what happened. They should have come to the court to say that, my lord, because I have this and this to be doing on the vacation, can you give us this adjournment? And that would have been resolved. That is what it is done. The Chief Justice cannot even interfere with that process because it is part of the judicial judge to determine which cases and how to hear the cases. But you see, the reason why he won't come is because he knows that if he comes, the judge will say, once again, let's do this one final trial so that you can now get your long vacation that you want.
He does not want to wrap up the cross-examination.
No, he doesn't want to. Basically, that is what I see. That is what he's avoiding. All this running around and all these interviews, the stress everybody brings toward this issue is because someone doesn't want to finish his cross-examination and be asked to file his submission of notice. That's all is happening. Because you only need one bill, one single bill.
So the concern, because it seems the GBA is saying yes, vacation courts do sit, but they will usually deal with interlocutory matters. So it's like, I don't know if I've...
Yeah, that is not correct statement. Interlocutory matters in respect of other court cases that are put before the vacation judge. So if I am a vacation judge in court A, the chief justice may add the cases of court B, court C, court D to my cases. The position is that when in respect of those courts, court B, C, and D, because I'm not the original judge, I can only deal with interlocutory matters. But the cases that are before me in that court, I can, because it's my case and it's my court, I can handle it the way I want. I can hear cases, I can do trial, I can do substantive matters, depending on what I want to do and what is fair and just. So the GBA is also misleading the public by creating an impression that they don't hear cases during the vacation at all, and that to hear cases is subject to the lawyers. How can any law say that lawyers will determine, if lawyers are allowed to determine what will happen in court? Do you know what's the essence of the court? Because the whole idea of having a court is to get someone who will hear both sides and balance the scale. So if you are saying that at some point it is the lawyer who can determine what will happen in court, then what kind of administration of justice is that? Does it even follow any rule?
Then what happens now? Because
Now,
I realized you were in court, they were not there. What happened?
So the first one, which was a Dubois, they were not there. And the judge was very clear that, well, they are not here, and he's aware that they said they won't come because of his legal vacation. But as far as he's concerned, it is his court and he has the power to conduct the cases, and he has scheduled it. Now, if they will come, no one can compel them to come to the court. But the case can also stop because a lawyer has decided not to come to court. So, accused person, you have a choice. You either come, convince your lawyer to come. If he won't come, get another lawyer to come and do the case for you. If you can't get another lawyer, you will have to do the cross-examination by yourself, which is also allowed. But whichever way, on the next agenda, that is what is going to happen. And the judge gave them 1 week to go and either find a lawyer, convince their lawyer to come, or prepare to come and do their cross-examination. So that is what the case is in the Dubois. Yesterday, the accused persons in Hanan, Papa Stock, they said their lawyers, both lawyers are all sick. They said the two lawyers are sick and cannot come. They show no evidence of any sickness, because in court, you cannot just go and use the word of mouth to say you are sick. You have to show some evidence of, sickness or medical report or anything like that. But there was no such evidence. Nonetheless, the judge said, well, sickness is not something that is predictable. So he's adjourning the case to Monday. They would have to, their lawyers, pending their lawyers' recovery and evidence that they are sick, so that they continue the case. So that's in the Buffer Stock case. The other cases, they will come on, I think, next week or two.
I see. Before I let you go, just one other issue, because I realized that you commented this on your Facebook page on the Bearco matter. There are those who are suggesting that because both the OSP and Yoko, if you read what they've put out, it means they were involved to some extent and provided some help. There are those who are of the opinion that if you have some information on exactly what happened, why not put it out? What do you say to that?
So you see, the Attorney General Office has been working on this case all this while since it came up. It is true the Attorney General's office that, Yoko is under the Office of the Attorney General. I think a lot of people don't seem to know that. Yoko is our investigative agency, so they are under our ministry. You see, so that is the reason why Yoko has been working with the foreign Americans to help them. While the Yoko and OSP were doing this. They've been doing this since 2020, when the case started, 2019, when the case started, when the investigation started, right? So it is not a special thing. We call it international cooperation or international partnership. So many countries send in their requests. If someone is in Ghana who has committed crime in those countries, we help them with our investigative agencies. And so it's a normal thing for our investigative agencies to help foreign partners, just as they also help us when we need such help. That is the spirit in which Yoku and the Office of the Special Prosecutor have been helping the Americans since 2020. So this case is not new in our system. It is not new in our system. So what we are doing is not really to start our own investigation, but to continue and to continue our investigation, and definitely relying partly on the evidence that Americans have also gathered, and we'll be using that to also do our part. The challenge is that as law enforcement, I think you media people should also understand us a bit that investigation is a secret, mostly a secret exercise, right? So sometimes the public expect that we'll just update them on everything that we are doing all the time, but it doesn't work that way. If you do that, the persons we are trying to arrest or catch, will know what is going on and they will change their strategy. So it is not everything that will be running to the media to announce to you that this is the stage we are reached, this is what we are doing. So it is enough for you to know that, the public to know that we are conducting our own investigation. But we cannot put out more than that for good reasons. When we realize that there is a good reason to put out some specific information, we will do so, especially when the investigation has concluded and we are about to go to court. We can give you full details. So it is not always the case that we can be giving out information, detailed information as the public may desire. So please bear with us sometimes when we are not giving you full disclosure. It's for good reason.
Thank you, Doc, for speaking to us.
Yeah, thanks so much, my brother.
Justice Srimsai Ede Nekasa Eba Evieno Sena Nombo Echere Nadren Efa Eye legal vacation saga ya ekoso ewo court concerning Atta Edubuahin ene afensu no other client omaka na yenti onanso na reaction.
Apparently, Atta has been doing cross-examination of one person for 3 months. The judge says, Basa, you have one more. I'll give you only one more day to wrap up. You cannot be cross-examining one person for 3 months. So what would have happened in the case if you had turned up for this vacation matter is that the vacation judge would have said, the judge said you have 1 day to wrap up the cross-examination. Yeah. Please do that. When he is done, then the judge will say, do you plan to file a submission of no case? If you do, file it. Because the judge can hear the submission of no case. Yeah. That one, the judge can hear it. Or the doc was also suggesting that the judge may not be in a position to hear that. But at least you have filed a submission of no case. They will have responded by that time. It will have been September and closer to the end of the vacation period. Yeah. So what he's avoiding is being asked to wrap up. Exactly. That cross-examination. It's quite interesting. Yeah. Yes. So really, he said that there's nothing really for them to complain about.
There's nothing to complain about. They are setting their own questions and answering same. You see what he said about the fact that the CJ has deliberately picked MPP high-profile cases to be looked into. That was a narrative sold to the masses. But he has clarified that that was not a case. That was not a case. There are a lot of cases that would be handled during this vacation.
Okay.
The MPP related ones are just part of it.
Yeah.
But he created the impression that it was
those
only
exactly cases, yes.
And that formed the premise of the agitation and noise, which even featured in their demonstration, democracy under attack. They made it look like Chief Justice has decided to identify key MPP related cases, and those would be the cases that the judges will look into during the vacation. That's the picture they painted.
But shouldn't the GBA have been a bit more what is the word to use? Detailed in the assessment of any such petition. Okay, so we've sent a petition to the CJ. We've copied you. If you want to understand exactly what is happening, why have these cases been referred to these judges? What stages are this case in? Do these lawyers have a genuine concern? Should that not be the inquiry before you go into jumping into this thing and that thing? All those arguments that don't make sense. Before you get there, should you not do an inquiry and get to the point that, okay, there's a genuine matter to be... Because they are the ones who are raising it. You are not speaking for all the other cases.
That's correct.
There are many people who are standing trial whilst the vacation is ongoing.
Correct.
You are not speaking for them.
No.
You are speaking for those few people who have raised these issues. So why should their cases be treated specially? You should explain to us. Else, then you become a parrot. Just parroting whatever they say. Like you are just backing them because it is them. So I don't know whether what I'm saying answer, but should that not be the approach?
That is supposed to be the approach. But you know, the GBA is... over the period has shown a certain likeness to some group of people. Any matter that involves them, whether the matter is good or not, they will always come and speak for them. This is one of those things. Were they even supposed to write to CJ?
The GBA.
Is a letter, no, not even the GBA. The two letters written by Atta and the former Attorney General.
Total, yes.
It's completely unnecessary.
Yeah. If you listen to all the lawyers, they're saying that what you are saying, you don't need to write a petition. You just need to go and stand before the judge.
Exactly.
And explain why you should not be in the position you are in.
That's all.
You haven't taken that step yet. Then the very first thing is you are writing a lengthy petition, making all kinds of claims, and even telling the CJ that, Massa, you are becoming... Meanwhile, the CJs have always issued warrants to justices to see to doing the vacation.
Absolutely.
So what has a CJ done wrong?
It happened under the former CJ, Dame. It happened under him. Court proceedings went on during legal vacation. Atta participated in legal vacation cases.
I'm sure he's done many times in his career.
So today they turn around to write to CJ to question why he's,
Yeah.
So the whole thing doesn't make sense, really. The crux of this whole matter is that they want to delay the process.
That they don't want this matter ahead.
Absolutely.
The vacation. At least they have a 2-month period.
Like the AG spelled out, once what they are seeking to achieve happens under this vacation, when they resume, the case will still not go on. Before I realize we enter next year, still the case will not be completed. It's just to drag the issue, to waste everybody's time, so that those who have sinned against the state will not get punished at the end of the day.
Because what would this would have done? And the timing is quite interesting, because if they are gone before that judge, the judge will have said, oh, but you only have 1 day of cross-examination to do. Please wrap up. And then you decide whether or not you want to file a submission of no case. So whilst we are on vacation, those processes can be exchanged. Then it will be heard subsequently. So the judge will be thinking, okay, by the time the vacation is over and a substantive judge takes over the matter, all the judge will have to do is to determine whether they should open their defense or not open their defense, because all the processes would have been before him anyway. So should they open their defense? Should they not open their defense? So it will have made the matter, it will have proceeded the matter to a certain place. But what Atta is doing now will be that he would conclude his cross-examination. The 1 day that he's been given, he would do it. The submission of no case, they will make no progress on it. So when the other judge comes in, what will happen is they will now do the wrapping up of the cross-examination. They will not give them time to file. If they feel that they were going to file a submission of no case, they will not file it. Even if it has no merit, it will have been filed. Imagine the time period. They will file, they give the other people. So this submission of no case, no matter will take the entire October off.
Absolutely.
Before you even come to November, where they will not be scheduling the defense. So automatically pushes the matter beyond this year.
Yeah.
So if you do those calculations, you realize that, And there are some, and another say, anyway, I think we should deal with every matter on the surface of it.
Yeah.
Okay, so I think perhaps we've broadened the discussion beyond the people involved.
Yes.
Now we're having a discussion on should lawyers work during vacations, should lawyers not work? No. What are the concerns of this group of lawyers? Why is it that the other lawyers whose cases may be before a vacation judge are not shouting like they are doing, but they are? When we sympathize with them, are we sympathizing with them or we sympathize with all lawyers on before vacation judges? What would that mean? Would it mean that if we all agree that everybody should go on vacation, would it affect all the other cases before the other judges or they alone? So if it is they alone, then we should look at their case on the merit of it, on the surface of it.
Yeah.
What is it? Where are those cases? What is it that will be asked of them that they can't do during the vacation? I think those are genuine issues that need to be raised.
That's it.
At this point. Now,
PENDREAM TV. Now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.